Hello, everyone, and welcome to our webinar today. And it's titled COVID-19 and its effects on your support obligations. So, with all that's going on, the entire country, the courts, everything's essentially closed down, and many people have had to face the unfortunate reality of losing their jobs. And this has raised a lot of questions. So, we will try to go through some of the questions that have been sent in to us, but the two most pressing questions we've seen is, am I expected to make support payments at this time? And what do I do if I don't receive my support payments? So I hope this webinar will be able to answer these questions. A little bit about me. My name is Angela Princewill, and I'm the founding lawyer at AP Lawyers. There's a team of fantastic lawyers that I work with. They're very passionate about what they do. And interestingly, they're still working very hard on helping resolve our clients' matters, despite, the craziness that's going on out there. So I'm going to jump right in. First, the courts expect that all existing orders would continue to be followed. So that's the starting point when it comes to your support obligations. So there's a lot that's changed, but that remains the same. So if you have a court issued order and or a separation agreement, the courts expect that parties would continue to follow that. But practically speaking, what do you do if you've been laid off and you simply just don't have the funds to pay? Well, we've come up with a few ideas. The first thing we always advise that you do, or that we've advised that you do in this situation, is could you just look at your budget? Are there areas where maybe you could make some cuts? And could you pay a lower support amount? That's just the starting point, right? If it's possible that you could make lower support payments, then we say start off by trying to negotiate that with your partner, right? So talk to them, and that's the first start, because as I said, the courts are closed, so negotiations are very important, and try to negotiate that lower support payment. And you know what, whatever little you can do, just act in good faith. And I'm going to eventually talk about, as a support recipient, what would be expected of you. But as the person paying the support, just see what you can do, and don't just, raise your hands and just say, well, I can't make this payment. Everyone knows what's going on out there. See what you could do and how you can maybe reduce the amount of support, and try to communicate that with the other party. Inform the other party as soon as possible. A lot of people have their expenses and lifestyle and everything structured, expecting to receive a certain amount of income every month. So if, as a support payer, you find out that for some reason you will not be able to make your support payment, whether all of it, or even if you can't make the full payment, timely communication is very important. You need to let the other side know as soon as you find out, because there will be some disruptions. They will need to make some changes, and the sooner they know what to expect, so they can in turn negotiate with other third parties as well, because a lot of times, the support recipient is counting on the income from you for things to cover things like rent and supplement car payments and all of those other bills that we have to pay. So as soon as you're aware that you will not be able to make these payments, please communicate it as soon as possible, so that the other party can make any necessary adjustments. So our second idea is just make sure you communicate in a timely manner as quickly as possible. And back to the first one, try to see if there's any way you can pay something towards your support obligations. If your support is being enforced by the Family Responsibility Office, and I'll just call them FRO for short, you may want to consider, maybe temporarily withdrawing your FRO enforcement, because with what FRO would continue to do if there's no order or agreement otherwise, is they would continue to withdraw the same amounts from your accounts. So you may want to, as part of your negotiations with your ex or the support recipient, you may want to communicate. You may want to let them know that maybe we should just withdraw our support from FRO at this time. It's temporary, and then we can work out a different amount and things like that. The advantage of that is you're not necessarily having to change the support amount on paper. You're not filing any consents and things like that. So it may just be easier for you to jump back in. It's easier for you to make the changes in real time without necessarily having to try to reach your caseworker and all of the required paperwork before they can actually make any changes on their system. Now, there's also the option of contacting them as well. So as the support payer, see if you could work with the caseworker and see what they can do. Now, I know that, with FRO, there's a lot of limitations at this point in terms of what they can do regarding enforcement and things like that. But it's always a good idea to work with them, work with the support recipient, and just see what kind of arrangements can be made, because you need to. The challenge with the COVID-19 pandemic, it's not, we're not talking about situations where a person knows that they're going to retire, for example, and you have a lead time, or people getting fired and maybe receiving severance. Everything is happening and changing so quickly, and that's why maybe withdrawing your order from FRO, negotiating with the other party, those things would allow you make changes and just get things going very quickly. Now, if unfortunately your financial situation is permanent, so the consequences of your job loss is of a permanent nature, you may be able to, that could form the basis of a motion to change when courts return to normal operations. And by permanent, I mean, not just someone that's been laid off and they don't know. Let's say there's businesses that are, suffering, that could be wiped off fully, right? So there's that threat of some businesses are going to shut down and never open up, or even some employees that could lose their jobs and never get rehired, at least not in the foreseeable future. So hopefully we'll see what happens come, after June 2nd in terms of how the court's operations would be. If it's back to business as usual, then your job loss in this situation may form the basis of a motion to change. And at that time, things like whatever arrears may have accrued, change to the ongoing support payments and things like that would be factored in. Don't forget to look at your agreement or your order. A lot of separation agreements, I find, include a mechanism to change support if there's a material change in circumstances. So look at your agreement. It may have a very easy way to, resolve this dispute. And especially when you're having to present your situation to the support recipient, if you let them know, well, we know no one contemplated this, at least not me. But, so it could be, well, we did not contemplate, a viral pandemic of this nature, but we did contemplate in the agreement how we can go about varying support if there's a material change in circumstances. And it may have a very quick and easy process or formula for you to change support very quickly. And then maybe when things even get better, it might have a mechanism for you to get back to paying the regular support payments. So take a look at your court order, take a look at your separation agreement as a starting point. If you are the support recipient and you didn't receive your support payment, well, what can you do? The starting point, again, I would say it's negotiation. You have to try to negotiate with the other party, either directly or through counsel if you both have one or if they have one. It's the most effective step. It's the only thing you really can do at this point. Again, because the courts have been closed since March 17th, and we're looking to reopen sometime in June, and only urgent matters are being heard now. The test for urgency is very high, and I understand that for a lot of people, they will consider their situation urgent, but the courts may not. It's a very, very narrow test, and except your financial circumstances are dire, and that's exactly the words from the courts in giving lawyers guidelines on what kind of matters we can bring at this time. It's dire financial circumstances. So it has to be, your situation has to be very desperate. It has to be extreme. If there's, if you have access to any funds in any way that you can use to cover the shortfall, your situation might not be considered urgent enough to be heard at this time. I had mentioned the Family Responsibility Office as well, suspending a lot of their enforcement tools. So it makes negotiations very important at this time. And, when the courts return to business as usual, when FRO enforcement is able to, resume in full capacity, then, if your support can be reinstated, things can be looked at, arrears would be calculated and things like that. Now, if your support is based on an agreement, and usually some agreements would say, well, if support is unpaid for a certain length of time, then you may be able to file it with the Family Responsibility Office. So if you're working with a support payer that's not even, communicating their situation with you, or you feel is just taking advantage of this pandemic, and there really is no reason why they should not be paying support, then you may want to consider filing your agreement with the Family Responsibility Office, so that, well, you file it with the courts, and then FRO gets involved, so that FRO can help you enforce it. It's usually the easiest and quickest way. And as I said, when we will get back to normal at some point, I know it just looks like it's never going to happen given how long this is taking. But yeah, things may get bad, but it will get better, and we will return to business as usual. And if a person's taking advantage of this time, or just, simply not following their agreements, then I would suggest, when courts reopen and things go back to normal, that you file your agreement with the courts as soon as possible, so that you can get FRO to enforce your support orders, and they'll be able to use all the tools that are available to them, which are usually very effective. So the takeaway from that in a whole is, it's important to negotiate, and you need to be flexible as well. So if they're offering, the support payer is offering a lower amount, well, maybe see how you could work with them. Are there expenses that maybe can wait? Are there things that, can be deferred, for example? It'll take a lot of patience. So with that, I'm going to jump into some questions that we had. So the first one says, I brought a court application for support, and with the courts now closed, what is going to happen? I think I kind of touched on that already. All family matters, well, the courts are closed, that's what I said, but all family matters are adjourned. Different courts have different practice directions and protocols on how they intend to deal with matters when the courts reopen. Some are just going to reschedule them. Others intend to have, like Toronto, I know, would be having a day where everyone's going to go in, and the courts would sort of see what stage their matter is, and that would form the basis of how their matter will be rescheduled. Obviously, again, trying to give priority to urgent or more pressing matters over others. But it remains to be seen. You would have to look at the various court practice directions. At this point, we're all still looking forward to June, and we're really hoping that would be a reality, because we understand that for a lot of people, this is going to cause a lot of hardship. So, with regard to what to do now that the courts are closed, unfortunately, it also means that your support application would not get heard until much later, and this will clearly, obviously, delay your support payments coming in. What I would suggest is to make sure, I hope your application mentions, depending on the date you brought it and things like that, the courts would go retroactively, whether or not you mentioned it. Now, obviously, if you're trying to get support before the day you issued your application, then you might need to make sure that application clearly states that you're asking for support retroactively. But if you brought your, application a month ago, and now the court's closed, and you're going to go several months without getting the support that you need, then obviously the courts would make sure that whatever support arrears that need to be made retroactively and things like that from the date of your application would definitely be factored in. Now, I know with the courts being closed, remember, if you're in a dire situation, if you're desperate and you're struggling financially, and you really need to bring, that motion, go ahead and do that. It's still, the courts are still open for you. The courts just want to make sure that we use judgment in the matters that are brought in front of them so that they're able to deal with the most desperate of people at this time, given the limited capacity of work they're able to do. The other question was, how are courts hearing urgent matters? So courts are hearing urgent matters by video conference and telephone for the most part. I understand that in some cases they're actually also using Zoom. We've been relying primarily on negotiations to get a lot of our matters moved along. I understand a couple of my associates will be bringing urgent motions because they absolutely have to, and those would likely be heard by video conference. The third question here says, I brought a motion to change spousal support, and now what? Okay, so as mentioned earlier, the courts expect that existing orders would continue. So unfortunately, even though you brought a motion to change spousal support and now the courts are closed, the courts will unfortunately expect you to continue to pay support. And I'm imagining by this question that you mean you're trying to get your spousal support payments reduced. It may also mean that you're trying to actually get it increased. So I'm going to answer that from two angles because I'm not very clear on the question. But if you brought a motion to change spousal support because you want your support payments to be reduced, and now this has happened, as I said, unfortunately, in that case, the courts would expect that you continue to follow the previous order. Hopefully, the support recipient would work with you and try to negotiate with you during this time. So that's something would say you should consider. Now, if you're in a desperate financial situation and you absolutely cannot follow the existing order and the other side is refusing to work with you to come up with a temporary solution, or maybe there's even just absolutely no way temporarily that you will be able to make your support payments. In that case, we would ask that maybe you're a suitable candidate to bring an interim motion to vary your support or just get a temporary order to deal with that. It may fall within the test of urgency. And if it does, then remember the courts are still willing to deal with such matters. Now, if you brought a motion to change spousal support because you should be getting a higher amount, then unfortunately, you may have to live with receiving those lower payments, and hopefully the support payer is still making those payments based on the existing order. Don't worry too much. You may be able to, depending on the payer's circumstances, you may be able to get the support looked at retroactively when the courts come back to make up for time lost. But unfortunately, you would have to continue to receive support based on the existing order. And the last question that I want to deal with here says, what would the courts do if I simply cannot pay? And I know we've talked a lot about, trying to negotiate with the other side and being reasonable, but sometimes you just simply can't pay. People, it's a very unfortunate time that we're in, and the reality is just for a lot of people, they simply just cannot make any payments at this time. What would the courts do? Well, that remains to be seen, right? We're going through an unprecedented time. The courts and the family law lawyers, we're really operating in uncharted territory right now. And my belief is if you absolutely cannot pay because your business is fully shut down, you have no access to capital with which to continue payment, if you've been laid off and you haven't received any EI payments yet, for example, and you have absolutely no funds with which to pay, then the court isn't likely to make any negative findings against you. This is not your fault. We're not looking at a situation where, there could be concerns about you being intentionally unemployed. This is happening to everyone, and the courts recognize that. And when the courts reopen, you may be able to get some relief with respect to the supports the support payments that may already have accrued. Because the fact that you're going through this hardship and you're not making the support payments doesn't stop your arrears from piling up, right? So when things get back to normal, or at least the courts reopen in some way that is more accessible to more people, then you may be able to get those arrears wiped off, and you may be able to get an order for a reduced payment, or something that works for your situation going forward. I feel we need to add that the courts would not look favorably at a support payer that can pay but chooses not to, and uses the COVID-19 pandemic as an excuse to avoid their support obligations. The courts are not going to look at that very favorably. There's going to be different tools, I feel, that would be factored in at this point to be able to address those. I mean, I'm thinking things like interest rates and interest being added on any support owing and things like that would be one way to deal with that. Give me one quick second here. So I'm seeing I'm just seeing a chat here, and I cannot multitask for the life of me. So this says there can also be urgent conferences requested for urgent issues, only focused on one or two issues for no longer than 30 minutes. So that's a very interesting comment, actually. So last week, the courts have expanded beyond urgent motions to now allow for urgent case conferences. So that can be a very effective tool for you with urgent cases. So if your situation is, urgent, and it may be easier to meet the test of urgency in this case when you're requiring just a conference versus actually requiring a motion. So that's something that you could try, you could try to reach out to the courts and try to get an urgent case conference going versus an actual urgent motion, which may be a higher threshold for you. So ultimately, a lot of patience is going to be required, and we recognize that this would cause hardship for a lot of families. Try to pay if you can. No matter how little, try to pay if you can. Work out a temporary solution. For the time being, both parties need to be reasonable. So calm heads really have to prevail at this time. The courts still remain, open for you if you need to bring an urgent motion, or now it's even been expanded to include urgent case conferences so that that's available to you. And I'm sure in the coming weeks, things will be expanded more and more so that situations such as this can be dealt with. But in the meantime, you have, the tools of negotiations available to you. You can bring an urgent motion, and now you can even try to get an urgent case conference. If you need assistance coming to a new agreement, given that the courts are shut down at this point, then you may want to consider online mediation and arbitration. At AP Lawyers, we offer online mediation, and I actually think that's the best option right now because, for sure it ensures that everyone maintains their physical distance and you're not having to travel to your mediator's office and all of that. So AP Lawyers, we do offer online mediation to assist with helping you come up with new agreements or very existing agreements that you're finding difficult to work with at this time. And I know a lot of mediators as well have the online mediation option going on. So that's all that I have for you today. If you want to watch this webinar again, I'm just going to pull up so if you want to watch this webinar again, I would strongly suggest that you subscribe to us on YouTube so that you can get notifications on when we have new content out there that, we have a lot of informative content that we share on YouTube from time to time. So I will upload this video there if you want to share it with someone, or you want to review this content again, you'll be able to do so. And for now, I don't see any more questions, and we got a lot more questions than this, but they were all sort of distilled into these broad areas. And again, to recap, and I know I'm repeating this, but repetition, it's the mother of learning. Just know that at this point, negotiate. It's your best bet at getting anything done. You have the options of urgent motions or urgent case conferences, and there is still the options of online dispute resolution available to you. So I hope this has been helpful, and we look forward to seeing you on more of our webinars.